straight to Joe.
Good afternoon. One of the great things about technology is that when it's working, everything is okay. And when there's a little problem, then you have issues. Good afternoon. My name is Kofi Barnes. I'm a judge of the Superior Court. During this presentation today, you are not going to see the PowerPoint. Or you might if we solve our technical difficulties. So the PowerPoint will be sent to you later on. I am speaking to you from the city of Brampton, and I'm speaking to you on behalf of the Association of Justice and Treatment Professionals, as well as on my own behalf. And we recognize and deeply appreciate the historic and current contributions of Indigenous people to this land. And in particular, we want to acknowledge and thank the Anishinaabe, Huron-Wendat, Haudenosaunee, the Métis, the Ojibwe, the Chippewa peoples, the Mississaugas of the Credit. We recognize their historic contributions to this land. We recognize the deleterious impacts of past and ongoing racism, and we voice our commitment to make the promise and challenge of truth and reconciliation a reality. Acquired brain injury is our topic for today. What I can tell you is that if you've got any questions, please send them through the Q&A. And at the end of Dr. or Joseph Waszlak's presentation, we'll have a chance to go through your questions. Now, our speaker today has a law degree. He's a PhD, and he's a founder of the Center for Neuro Law and Equity based in California. This session will be recorded, and you receive a copy of the recording at the end of the presentation. This is the first of two sessions. The next session will take place on November 13th, 2024, at the same time. And it will be a session on traumatic brain injury, complex needs, and associated challenges. So Joseph, I'll just turn it right up to you to take us through this.
Thank you very much, Justice Barnes. That introduction is a lot more kind than I deserve at this point as we struggle through technical difficulties trying to get my PowerPoint on board. I'm hoping that one of my colleagues will be able to simulcast it for me, so I don't have to talk through a PowerPoint that none of you can see. But until that happens, I'm just going to walk through my PowerPoint remotely. Again, I apologize, this is suboptimal, and I do not understand why I'm having these technical limitations. Figures it would happen right at the time of a talk. I'll see if one of them can step in to cover me. But until then, I'm going to get started talking about brain injuries and barriers to participation. So like Justice Barnes kindly said, I'm a neuroethicist by training. I did my law degree and my PhD training simultaneously. And my expertise is on brain injury and social legal behaviors. So the behaviors and cognitive behaviors that are particularly relevant to TBI in the law. And what I wanted to talk about today was how TBI, traumatic brain injury, and neurodisability might affect a person's ability to navigate legal contexts and to navigate legal settings. So I haven't outlined in a learner goals in the slide. I apologize that you cannot see them, but when you have access to them, hopefully you can follow along with those and gain something from this talk. I'll start by just defining what TBI is, TBI 101. It's an external injury that disrupts normal brain function. Typically what happens is somebody is in, say, a bad car accident or a fight. They suffer mechanical injury to the brain, so the brain gets physically damaged and the cells and tissues in the brain get physically torn. And then they suffer biochemical disruption, so the cells and biomolecular functions of the brain don't work as a result. And because of those injuries, TBI results in disrupted functional connectivity. So your brain, as a giant living electrical conductor, basically, doesn't work as efficiently, and it doesn't work as well as it did before the injury. As a result of this functional connectivity disruption, TBI is associated with a whole ton of cognitive behavioral impairments. I've got a chart here on this slide, and when you can see it, you'll see that I've highlighted some of the cognitive and behavioral deficits, things like attention, memory, decision-making, reasoning, just a whole host of deficits associated with TBI. Now, I want to stress at this point that when we talk about traumatic brain injury as a disability, we need to keep two important things in mind. Number one is that TBI is a chronic condition. So an injury to the brain is not necessarily like an injury to, say, an arm or a leg. We can't put your brain in a cast and just wait for it to heal. Recovery for TBI often takes years and years, if recovery happens at all. And so it lives with the person as a chronic condition over the course of their life. And number two is that TBI exists, or it presents, as a spectrum of these cognitive behavioral deficits or impairments. So cognitive behavior is not a binary yes/no trait. It's not that you either do have it or you don't. You can display it across a kind of spectrum of ability or a spectrum of capability. And I also want to stress that disrupted connectivity within the brain is not the same thing as no connectivity. People without any brain connectivity are in comas or in vegetative states. So even though persons with TBI might have disrupted connectivity, they still have brain connectivity. It just simply can't work as well as it did before the injury. And these considerations tie us into the topic of TBI as a disability. And I'm going to present a model of neurodisability in which it's defined as a series of functional limitations that arise from the interaction of a person's health conditions, a person's environmental conditions, and a person's individual or personal conditions. The model that I've just described is called a biopsychosocial model because it accounts for a person's biology, a person's individual psychology, and then a person's social environment. And it considers how those factors implicate or affect cognitive behavioral functioning at various levels. So at the level of the brain, at the level of cognitive behavior, and then at the level of social behavior or social participation. So if you want to take TBI as a neurobiological health condition, you can simply plug it into a biopsychosocial model. And then we can see that the various cognitive behavioral deficits I just talked about, attention, reasoning, decision-making, that sort of thing, those reflect functional limitations within the biopsychosocial model. So again, individuals with TBI can still perform those functions. They just might be limited. They might be poor quality, or they might be slower, or they might be both. Now, just those behavioral deficits alone might lead you to believe that TBI has a lot of legal relevance, and it does. But one important relevance of TBI to the law is that persons with TBI and other neurodisabilities more generally are extremely overrepresented, and they face pretty bad outcomes in the law. So as some just basic numbers, traumatic brain injury occurs in about 2% of the general population, and it occurs in over 50% in incarcerated or law-involved populations, sometimes as high as 90%. So 25 times higher in these law-involved populations than in the general population. In addition, persons with TBI and other neurodisabilities tend to self-report pretty bad experiences. Communication is also, or is frequently cited as a major hurdle, and we'll talk more about this as we talk about social legal behaviors. And persons with TBI or other neurodisabilities often face disproportionate treatment by legal actors. So they face different charges and get charged at different rates and that sort of thing. So there's a very clear need to reconsider how the law is interacting with persons with these sorts of injuries and these sorts of neurodisabilities as they attempt to navigate their own legal contexts. Okay, that includes my primer on TBI and neurodisability. I have a slide here to pause for questions, but I think instead, what we can do is pause and see if Flora or either of my colleagues is able to share the slides so that we can continue with the rest of the talk.
I'm getting an error and I'm trying to figure it out. So, sorry, Joe.
We are just doubly cursed on this poor presentation. We'll be fine for time. My talk was only supposed to run for about 35 or 40 minutes. So.
Okay, I'm still working on it.
Okay, well, instead of having dead air, I will just continue on with the rest of the talk. And again, I really do apologize that you can't follow along with these slides in person, but we'll do the best we can. All right, I'm moving into the major substantive portion of my talk, and that is TBI and what I call social legal cognitive behavior. So we're going to address two questions in the second portion of the talk. We're going to ask what cognitive behavioral functions are particularly relevant to TBI and the law. And by that, I mean, what levels of functioning at the level of the brain or at the level of cognitive behavior are particularly relevant for persons with TBI in the law. And the second question is what social legal behaviors are particularly relevant to this topic. So what behaviors at the level of social participation or behaviors that are directly applicable to legal contexts are implicated by TBI or particularly relevant to neurodisability. Question number one has a pretty easy answer for the purposes of my talk. And I'm going to focus on something called cognitive communication as a cognitive behavior that is highly implicated in both TBI and the law. Most of you are probably familiar with what just communication is. Because you've all come through legal trainings, you've probably had some sort of communication skills class or lawyering skills class where you talked about communication, language and nonverbal communication and physical speech and all those sorts of things. Those are all visible aspects of communication. That's kind of what you interact with or present as you communicate. But you might be less familiar with what your brain is doing under the hood, as it were, as you are communicating. It turns out your brain does a lot to support communication. You have to remember information during and about communication. You have to recall information. You have to pay attention. You have to make decisions about what you're going to say or what you're going to do during the conversation, all those sorts of things. These are all invisible aspects of communication. Like I said, your brain is running them under the hood, even though they don't manifest in the communication itself. And all those cognitive mechanisms or functions I just talked about that bridge the gap between your brain and communication, those are what we call cognitive communication. Cognitive communication just means the mental mechanisms and functions that underlie the ability to encode and decode information. Cognitive communication is really, really important to the intersection of neuroscience and the law. Not only do you need cognitive communication in every legal context, because obviously you always have to talk to somebody or you always have to read something, but there's also a pretty major and a pretty common disconnect between cognitive communication limitations and how those limitations get interpreted by legal actors. There could be very serious legal consequences if legal actors interpret cognitive communication limitations, quote unquote, incorrectly. I've got a chart on this slide by an assessment of the New Zealand legal system. And they noted that a number of cognitive communication limitations like language and comprehension difficulties and communication difficulties often get interpreted as things like obstructive behavior or guilt or being belligerent or acting stupid. Those are pretty bad things to have a judge or a legal actor think of you, but those are common ways in which those sorts of cognitive limitations, like not being able to follow along with a conversation, not being able to structure your speech very accurately or very fluently, get interpreted. And part of the reason is that because, like I said, cognitive communication is invisible, those sorts of limitations look like or present as these sorts of character trait, personality flaws. So it's a very serious risk of misinterpreting a functional limitation in cognitive communication as an intentional behavior. And that's definitely not always the case. A lot of the work that I've done on cognitive communication in the law has been an attempt to build models that are usable in the law or that kind of capture the intersection between the law and cognitive communication. And I've got one that defines cognitive communication as will be represented in your slides. So I define cognitive communication as the ability to access information, as the ability to internalize information, and as the ability to interact with information. And then each of those three functional abilities is supported by cognitive resources. So memory resources, attention resources, decision-making resources, that sort of thing. I spell this all out in the slides if any of you are interested in getting into the kind of neuroscientific weeds. But what I want you to think about as I present this information to you, and what I want you to learn about cognitive communication, is that you can conceptualize it as a pool of cognitive resources. So it is a set of cognitive resources that facilitate communication behavior. That's the kind of practical or pragmatic role that cognitive communication performs. What that means for communication behavior is that, as is true for any other resource or anything else that depends on a resource, if a person has fewer resources or if they face increased pressure on those resources, then they risk limited communication behaviors, or they experience limited communication behaviors. And when I say limited, I mean slower and or poorer quality, like I was talking about for the effects of disrupted connectivity on the brain. So just like any other resource, if you have fewer resources, or if it's harder for you to access those resources, or if you face additional pressure on those resources, the output of those resources might be correspondingly limited. And that's the same case right here for cognitive communication. Fewer resources that support cognitive communication translate into limited communication behaviors. So what we can do for our model of neurodisability, that biopsychosocial model I talked about just a little bit ago, is we can substitute cognitive communication for functioning of the brain and of cognitive behavior. You'll see that updated graphic when you have access to the slides. What that means is that we can consider how health factors like a traumatic brain injury, for example, or how other factors within the model might affect functioning specifically within this resource model of cognitive communication. Another reason that makes cognitive communication very relevant to our discussion of brain injury in the law is that cognitive communication limitations or impairments are very, very common following brain injury, something like 70% prevalence. So the vast majority of persons with these sorts of injuries will have cognitive communication limitations. And if you compare the resource model of cognitive communication I just talked about to the cognitive behavioral health effects associated with TBI, remember there's like attention, reasoning, memory, that sort of thing, those map onto impairments across all three functional categories of the model. So limitations in accessing information, limitations in internalizing information, and limitations in interacting with information. All common and expected or predictable consequences of a brain injury. So I've specified that illustratively and conceptually in an updated model in which we show that TBI causes reduced resources within our cognitive communication model of neurodisability. That translates into limited or impaired cognitive functioning, and that translates into limited or impaired communication output. So TBI, fewer resources at the level of cognitive communication, overall limited cognitive functioning, overall limited communication output. That's kind of the loop I want you to think about in terms of TBI and cognitive communication. So that lets me answer the first question from this section. What cognitive behavioral functions are particularly salient to TBI in the law? It will be this cognitive communication. Like I said, it's implicated in all legal interactions. You can't talk to somebody or read something without cognitive communication. It's highly susceptible to functional limitations in brain injury, like I talked about. All these things depend on intact brain connectivity, so they're very vulnerable to these sorts of injuries. And they're highly susceptible to misinterpretation. Again, they're invisible, you can't see them in communication, so they're often interpreted as intentional behavior or some sort of character or personality trait. Okay, that concludes that portion. I have another slide for a pause here. So fingers crossed, we might be able to salvage something of this talk if we can get the slides demonstrated.
Unfortunately, Joe, we're not going to be able to
Any
do
luck
that.
on that? Oh gosh, that's okay. I'm so sorry, everybody. I know this is definitely a less than ideal way to interact with this information because it's so visual and textual. But I do hope that the combination of the recording and the materials later will still provide some value. We'll carry on all the same. Okay, we're going to continue to that second question. What sorts of social behavioral topics or actions are particularly salient to TBI and neurodisability? So we've talked about functioning at the level of cognitive communication. It's at the level of the brain. We're going to talk about functioning at the level of social behavior or social participation. Now, my work as a scientist has let me study 3 of these behaviors in particular. I've looked at legal language comprehension, so understanding language. I've looked at social legal reasoning, so reasoning about legal fact patterns or legal events. And I've looked at social legal discourse. Discourse is just a technical term for narrative speech or kind of structured conversational speech. And I found that TBI negatively impacts all 3 of these social legal participatory behaviors. So there's an effect of TBI on understanding legal language. Persons with TBI are less accurate, and persons with TBI are slower, so it takes them longer to be less accurate. And that just means that persons with TBI, when compared to uninjured persons, have poorer quality comprehension of legal language. So they are functionally limited when they have to understand legal language. The same thing is true on tasks of legal reasoning. So the TBI group is less accurate, so they can't comprehend as well, and they're slower. It takes them longer to not comprehend as well. And again, this translates into poor quality social legal reasoning, and that means that their reasoning in legal contexts or about legal scenarios is functionally limited compared to uninjured persons. The same is also true for that third social legal behavior, discourse speech. We found that the TBI group made more errors basically as they were speaking. So their speech was less grammatic and syntactic, it was less coherent, it was less organized, and it was less informative. So they have poor quality social legal discourse, that's conversation or speech about legal topics. And that means that they're functionally limited in this task of social legal discourse when compared to uninjured individuals. So what we can do with those results is we can plug that into the biopsychosocial neurodisability model that we've been working with. And we can see that not only does TBI limit cognitive communication resources and translate into functional limitations in cognitive communication, it translates into functional limitations on these tasks of like explicit social legal behavior. So on tasks that a person would have to do as part of a kind of standard legal trajectory, persons with TBI will be directly limited or directly impaired compared to uninjured groups. So to answer question number 2 for this portion of the talk, what social legal behaviors are salient to traumatic brain injury in the law? The 3 I just talked about: language comprehension, reasoning, and discourse speech. I found a main effect of TBI on all of those. So the TBI group does worse than the uninjured group on all of those behaviors. There's a causal role of cognitive communication mechanisms. I'm afraid you can't see this because you can't see my slides, unfortunately, but some of the mechanisms or resources that support cognitive communication in part explain the poor outcomes on these social legal behavior tasks. So we're just completing that loop between brain injury, cognitive communication resources and functioning, and social legal behavior. And all these behaviors will be directly applicable to legal contexts. I studied actual courtroom legal language. We talked about actual legal topics. It's about as close as you can get in an experimental scientific setup to studying what a person would have to do if they were in a legal context. So with that, I can conclude with a full analysis of TBI and social legal cognition, traumatic brain injury as a health condition that will reduce cognitive resources that support cognitive communication, that will translate into poorer quality cognitive functioning, and that will in turn translate into poorer quality communication generally. So limited communication generally, limited cognitive functioning generally. TBI will also translate into limited social legal behaviors specifically. So specific functional limitations on the sorts of behaviors that persons would have to do as they interact with legal stimuli and information as they attempt to navigate legal contexts and legal actors. There's just one quick caveat as I conclude this kind of scientific discussion of the topic. We have to be careful that we don't conflate group level characteristics with individual level risk factors. So as a scientist, what I do is I study one group of persons with brain injury and I compare them to another group of persons without brain injury. That lets us control for factors like age and education and all that sort of thing. And it lets us determine population level characteristics based on the behavioral deficits that we can observe in our studies. For any given person, say for any given person with a traumatic brain injury, we can say it's possible or likely that they'll have those behavioral deficits, but we can't say for sure. That's just beyond the scope of interpreting these sorts of scientific results. So think of individuals as having an individual level risk associated with TBI, but think of TBI as a whole or as a group as having the characteristics I talked about. So as a whole, persons with TBI will show those sorts of cognitive limitations and behavioral limitations when compared to uninjured peers. But for any given one person with TBI, they're just going to have the risk of having those limitations. All right, let me summarize this into 3 key takeaway points. Hopefully this helps some of the information consolidate and transmit as I present it purely verbally. Key takeaway point number 1 is that TBI can be best conceptualized as this biopsychosocial disability. So it represents functional limitation across these various levels of functioning in the brain, in cognitive behavior, and at the level of social behavior or social legal behavior. Key takeaway point number 2 is that cognitive communication, this construct I've been talking about, is an essential component of not just cognitive behavior, but of social legal cognitive behavior. And if you have a condition or if you are in a context that limits the amount of cognitive communication resources you have, or that puts increased pressure on those resources, then you are going to have an increased risk of functionally limited communication output. Just like any other resource, if you have fewer resources or you can't access the resources you do have, the behavior that depends on those resources, the output, is going to be correspondingly limited. And finally, key takeaway point number 3, we've observed direct causal links between TBI and poorer performance on these specific tasks of social legal behaviors. So that means TBI as a group will show increased social legal behavioral deficits in understanding legal language, in legal reasoning, and in legal conversation. And that'll translate into functionally limited participation in social legal contexts. So they will just have a harder time navigating legal interactions or interacting with legal actors. Okay, what can you do as a legal actor to try to better accommodate persons with TBI? I've got 3 strategies for you here. Again, you'll have access to these, so they'll be more use to you when you have these. But strategy number 1, reduce pressure on cognitive communication resources. Strategy number 2, use alternative communication strategies. And strategy number 3, divert persons away from the system in the first place. So strategy number 1, reducing pressure on cognitive communication. These might be more, the most kind of self-explanatory or intuitive strategies to support communication. Things like slowing down communication. That doesn't just necessarily mean speaking more slowly, but using less information per sentence. So less complex sentences or sentences with fewer clauses, that sort of thing. And giving people more opportunity for breaks. So giving them more opportunity to digest and process information. You can also use nonverbal communication aids, like I would have done with this talk if you could see it. But visual aids and written guides are a great way to support persons with cognitive communication limitations because it stores the information outside of their head effectively. They don't have to interact with it in real time, and they can parse information at a rate more in line with their level of cognitive communication functioning. And number 3 is to control external distractions. So if you're able to limit the amount of noise in your courtroom, if you're able to select venues that might be less stressful or have less pressure associated with them, that'll alleviate some pressure on those cognitive resources that support cognitive communication too. And what you're basically doing, and you'll see this illustration in my model here, is you're basically applying positive pressure within the biopsychosocial model onto cognitive communication. So you're alleviating some of the burden on those resources and hopefully improving cognitive functioning as a result. Strategy number 2, that's using alternative communication strategies. So the one I always stress, and one that I think is very applicable to legal actors, is to avoid closed questions as you can. Closed questions are generally yes/no questions. But because cognitive communication and cognitive communication limitations are invisible, as I've talked about, the only way for you to be able to understand what's going on under the person's mental hood is to give them the opportunity to show their work, as it were. So having people explain things to you in their own words, or having people tell you what their understanding looks like, not just asking, do you understand, is a good way to kind of check their cognitive communication work and gauge whether or not their understanding is truly intact. I will say here, we do know from some experimental findings that if you ask people, do you understand, particularly people with brain injuries, they tend to nod their head and say yes. I have been in more courts than I can remember, and I can only count on one hand the number of times I've seen a defendant or a party say no to a judge when the judge asks, do you understand? And I guarantee you that comprehension rates were not 99.999%. So avoiding closed questions, giving people an opportunity to explain their understanding or their cognitive communication is a good way to go. Another point in the strategy is to use horizontal dynamics. This model is more common in social work, which my colleagues might talk about later, but it basically just illustrates a horizontal orientation between the legal actor and the lay person. So instead of communicating down to a person as a judge, for example, you might be able to work in parallel with them to solve problems and communicate. A good example of something like this would be, instead of telling somebody to just go to a room on the second floor of your court and pick up a certain form, you might be able to help them there with like a clerk or something, or to give them a written guide that kind of specifies it with a map and things like that. Another good strategy for alternative communication approaches is allowing communication aids. These models are more common in other jurisdictions, appropriate adult models like in the UK or in Australia, but having a family member or a rehab worker or a like close confidant who can kind of translate communication to a person with brain injury can go a long way. And again, that might alleviate burden off the person and help them communicate with the cognitive communication resources that they do have. And if we apply these strategies to our model of neurodisability, it's the exact same thing. You're simply just applying positive pressure onto cognitive communication within the model as you attempt to provide these sorts of modified or reformed communication strategies. And strategy number 3, like I said, is simply just keeping people out of the system in the first place, and probably preaching to the choir to a group like this. But we know that upstream determinants of health, the things that affect brain injury, like education and housing and outcomes after brain injury, those things also affect legal outcomes too. So targeting those determinants is a great way to, one, keep people out of an injury trajectory or to help them on an injury trajectory, but 2, keep them off of legal trajectories in the first place. Similarly, being able to prioritize community resources helps persons with neurodisabilities or brain injuries get the sort of rehabilitative care they need. I'll stress at this point, and I've got this spelled out on my slide here, but TBI and criminality are not interchangeable. They are not the same thing. You'll note I've said that TBI is associated with functional limitations in behavior or behavioral impairments. You'll notice I've never mentioned that persons with TBI are more likely to commit a crime or are more likely to be involved in criminal behavior. It's true that TBI might be associated with limitations in like behavioral regulation and impairment, but what's happening is that persons with TBI have cognitive limitations and have limitations in behavioral output, and that translates in a poor ability to navigate schooling, navigate healthcare, navigate employment, navigate social contexts. And unfortunately, in societies like ours, if a person can't navigate those sorts of social nets that well, they often end up in the legal system. And I've got on the slide here that carceral hammers find carceral nails. We know that persons with these sorts of injuries, what they need is rehabilitation and medical help. They don't necessarily need to be punished or detained in what particularly criminal legal systems kind of traditionally justify their treatments of persons. And finally, and relatedly, I think it's really important to start to redefine what justice means for these sorts of conditions, for TBI, for neurodisability. Organizations like UNICEF have started some reimagined justice campaigns that explicitly say, at least for children, that children with neurodisability shouldn't be in legal systems at all. And I think that's the case for adults as well, for anybody with a TBI. And it's also worth considering whether the sorts of disproportionate outcomes we see for brain injury or for other neurodisabilities might not necessarily be like a technical flaw in the system. It might be the system working as intended. Tying it back to what I just said, it might be the fact that these sorts of persons are disproportionately represented within particularly criminal legal systems, because that's what those systems are trying to do, divert those persons out of society that they simply can't navigate as well because of their cognitive limitations. So what that means for my model, and I've got a big like X or stop sign going through it, is that it simply doesn't even apply. You don't have to worry about social legal behaviors or functional limitations to cognitive communication and the law if you can just keep people out of legal context in the first place. I've got a bunch of resources spelled out in my slide that are great. There are resources specifically for organizations that do this sort of direct work. I've got a link to a kind of online free learning course about acquired brain injury, which I believe has been a previous topic and which is kind of an umbrella category of traumatic brain injury. If anyone wants to learn more about that specifically through, like videos and little learner courses, that sort of thing. And I've also got a resource for a project to plug my own work that I was working on with some colleagues over at McMaster University in Hamilton there in Ontario. That's specifically for TBI and youth, but we've got some good resources and information about how to better support and assess persons with brain injuries who might be in legal contexts. Okay. Well, some of you might have noticed that even though I've been talking a lot about a biopsychosocial model of brain injury and legal behavior, I didn't really talk about the psychosocial part. I didn't really talk about how environmental factors and how individual factors might contribute to a person's functioning and might impose barriers to participation in the legal system. And that's because I will be passing the baton off to my colleagues, and they're going to pick that up in session 2 and look at some of the complex needs associated with brain injury and the legal system. Everything I've talked about has just been TBI as just a single factor, but as you can probably guess, traumatic brain injury does not occur in a vacuum. Persons with brain injuries or other neurodisabilities are facing all kinds of pressures or all kinds of limitations. And if we can better understand some of these complex needs and complex interactions, we can better support and accommodate these sorts of persons as they attempt to navigate legal settings. Okay, thank you very much, everybody. I have my references and credits and everything at the slide. And I think with that, I can finally end my talk. Thank you so much for your patience. And like I said, I do apologize that this was not the ideal way for you to interact with this information. But if anybody does have any questions, if there's anything we can discuss, I'd be more than happy to do that in the remaining time. Thank you very much.
Joe, thank you so much for that presentation. Given the circumstances, you did an incredible job. You always do an incredible job with your presentations.
That's very kind. Thank you. I do apologize for the technical errors on my end, but I hope the combination of the recording and this talk with the materials will be of use to the judges and the justices. Thank you.
Yes, we'll be sending out your presentation after. We'll send it out through Justice Barnes. So happy to have questions or comments. Would love to hear your own comments. Anyone in the audience about your work with clients with brain injury and how that process is working in the courtroom as well. We're very curious about that with your work. So if anyone has comments or questions, please, we're going to open it up in the chat, in the Q&A, and just verbally as well, please.
I'm more than happy to talk about some of my client work and legal work too with some of these populations or with persons who have some of these cognitive behavioral and cognitive communication limitations. I could talk about a number of cases if that's of interest.
I have a question. My question is, you said that we should avoid asking yes or no questions, right?
Yeah.
So could you give us a practical example? If we should avoid the yes or no questions, what kind of questions do you suggest we ask? Just some practical example.
Yeah, absolutely. So the type of legal, excuse me, experiments I was doing were what are called plea colloquies in the States. I think they're called plea cautions or plea warnings in Canada. But as individuals are attempting to enter a guilty plea, you have to, the judge will assess their understanding and their voluntariness of the plea. And so in the States, and I believe in Canada as well, that typically requires a bunch of questions about the defendant's understanding of the crime, the defendant's understanding of their rights, the defendant's kind of cognitive and mental standing, that sort of thing. So in America, for example, they get a number of warnings about some of the constitutional rights that'll be affected by the plea. So the judge will say something like, do you understand that, if you are not a US citizen, then your plea to this crime will or could affect your ability to, access services and rights based on citizenship or something like that. And then what generally happens is that the defendant will nod their head and go, yes. So an example like that, the judge could present that information and say, okay, I've told you about the implications for immigration based on this guilty plea. Can you tell me what that means to me in your own words? Something like that. I understand the practical limitations. I've been through the courts. I'm a lawyer myself. I understand that there are only so many hours in the day and so many opportunities to divert from, standardized court forms and standardized colloquy language and that sort of thing. But it really is the case that people just kind of nod their heads and say, yes, I do understand. No, I don't have any more questions. I also understand that a lot of the onus for these behaviors is or should be shouldered by the attorney, which is generally the case, but we can't discount the fact that a lot of these clients might not necessarily have access to like regular or very involved legal representative. They might have a court-appointed attorney that they've only met with just for a few minutes before their court appearance, for example. They might want to proceed pro se just because they don't trust legal actors or because of negative experiences within the legal system. So there are a lot of hurdles and upstream antecedents of the sorts of social legal behaviors when they occur in the real world. But being able to just ask somebody, here's what I talked about when I talked about these constitutional rights or these various rights, what does that mean to you in your own words? Tell me what you understand, that sort of thing.
There's a couple of things in the chat. One comment, justices must communicate to accused persons verbally and cannot rely on visual or written cues assists.
Yeah, and like I said, I understand the practical limitations when it comes to trying to implement these sorts of procedures. And if your court has a particular rule, or if you're bound by certain legal standards, I know there's not too much you can do. And that's just one of the features of the law. I think it is highly verbal, it's highly language based. And unfortunately, that just means additional pressure on the sort of cognitive resources that people need to navigate it. So any attempt or any ability to simplify language on forms, any ability to include like a visual learner pamphlet that could be kept outside of court. I've seen those, for example, that talk about, due process rights and substantive rights and that sorts of things. Anything that can offload information from the contemporaneous experience of a communication with a legal actor, and just allow the person with a brain injury or a neurodisability to store that information somewhere else can help overcome some of the limitations that they might face in just kind of a standard real-time interaction.
Yeah, and something that we're going to be talking about next session is communication intermediaries, and that might be something that might be helpful as well. So
yeah, that's a lot of what the appropriate adult model I talked a lot about, having a kind of third person, or like a kind of neutral party, as it were, to kind of bridge the gap between the legal actor and the person with a brain injury or a neurodisability, especially if, like I said, that person is a friend or an acquaintance or a rehab specialist who has more formal training in communication strategies, or is better able to work with the person as a biopsychosocial living being, and just understand the conditions that they face more better than a judge might be able to get if the judge is seeing, hundreds and hundreds of parties a day, for example.
Right. And a question, other than not asking yes or no questions, how can we assist someone to understand what we were saying from a practical perspective, i.e., if we were trying to communicate?
Yeah, that's a really good question. Ultimately, I'm going to tie back to what I said during the talk. The only way you can truly understand whether a person understands is to get inside their own head and see what their cognitive communication is actually doing. That's impossible. You can't do that with a brain scanner. You can't do that with a host of psychological tests. So the best you can do is find these behavioral proxies of understanding, or to try to facilitate behavior in as conducive a way as you can to just promote understanding. So making the context as conducive as possible, eliminating distractors or stressors, that'll help resources. Using those sorts of open communication strategies, that'll help resources. Giving people communication aids, making sure attorneys are aware of what brain injuries are and how that might affect their client. All of these things might do just a little bit, but a little is better than nothing, and a little could go a long way in terms of functional limitation. Understand that we're talking about pretty complex social systems here with the law. I mean, ideally, you would have to restructure the whole thing from the ground up if you wanted to truly accommodate persons with brain injury. And I know like I said, I sympathize with your positions. It's hard to be a legal professional with the demands of just the profession itself when you're encountering these sort of complex behavioral needs, but doing whatever you can to help is better. I will also say that simply giving people the benefit of the doubt, I think, goes a long way. I've worked with some individuals who have these sorts of limitations, and you might just have to explain things to them over and over and over again. You might have to answer the same question 5 or 6 times in a row. You might have to give them more of a wider berth if they're, breaking courtroom etiquette, or if they're engaging in like improper direct communication with a judge or something like that. I've seen examples like that. And again, I think it's kind of human nature to interpret those sorts of behaviors as intentionally bad behavior or as some sort of character limitation, but it might just simply be the case that the person has heard you explain something 5 or 6 times and just simply can't remember it as well, or they can remember it, but by the time they're translating that into action, that gap has kind of been opened up already, or they struggle reasoning through the consequences of your instructions or of your interactions. So all these behaviors can just be so complex in legal contexts that even just recognizing that what might look like bad behavior or a difficult party or a bad attitude might just be cognitive communication limitations, might just be some of these functional limitations that are actually going on at the level of the brain, not just at the level of personality.
Thank you. I don't see anything else else in the chat. So thank you, Joe.
Those are all good questions. Thank you so much. Again, I really do apologize, everybody. I'm so sorry for the technical limitations. I was saying at the start, I had a Teams presentation that worked perfectly fine last week. Just bad luck that it didn't work this time, but the slides will all be available. I hope this was of use. And please do stay tuned for part 2 with my colleagues, because they're really going to expand what I've talked about to bring in some of these social needs and complex behaviors that are always affecting persons with brain injury and neurodisability.
And maybe I'll just make one comment. Justice Barnes is going to be sending out some materials after this session and after the next session. And we are doing a study on looking at traumatic brain injury around conditions of release. And we are just hoping that some of you may be interested in speaking with us about this topic. Your perspectives on this topic would be very important. And so if you're interested, please reach out to us. And as I say, Justice Barnes is going to be sending out those materials. So would be happy to hear from you and have your perspectives. So thank you.
Joe, I've got one question. If you can answer it in like 15 seconds, because we are almost done. If, let's say, I'm preparing bail conditions, right? Somebody's released, I'm giving them conditions. Can you think of one condition that would be very unhelpful for somebody who has acquired brain injury?
Oh, you could not have teed up part 2 of this talk better if you tried. Okay. My colleague Arthur has been specifically looking at bail conditions and issues related like that. So if we can put a pin in that comment, okay, they're gonna answer that question 1,000 times better than I could in part 2 of the talk.
All right. So with that, Flora, I guess we can wrap it up, right?
We can wrap it up. Thank you.
Right. Well, Joe, thank you so much for your presentation.
Yeah.
The association will take responsibility for the technical difficulties. It's not your fault. We'll figure out what happened to make sure it doesn't happen again. Flora and Arthur, we look forward to seeing you again on November the 13th at between 1 and 2. And all the judicial colleagues who showed up, thank you very much. We'll send the recording and the PowerPoint. So we'll be in touch again. So with that, have a good afternoon. And thank you so very much.
Thank you.
Thank you, everybody.
Okay. All right.
Bye.